Yes, Mr. Nafta.
Your lordships want me to read paragraph 4.
Just a few lines from that para and then we can move on to the next one.
One thing which I want to bring to your lordship's notice. This, if your lordship sees the first para of the judgment, where it refers to the presidential order of 1954, in the very first para of the judgment. Now, the Article 81 was amended, was modified with the concurrence of the state government. There was a democratic element in that. Now, in this context, kindly see para 4. Some of the observations in para 4, as I said, are too wide. And if they are accepted in toto, the entire constitution of India can never be applied to Jammu and Kashmir. If taken to its logical conclusion. But even assuming that the introduction of indirect election by this modification is a radical alteration of the provisions of Article 81, the question still remains whether such a modification is justified by the word modification as used in Article 371. We are here dealing with the provision of a constitution which cannot be interpreted in any narrow or pedantic sense. So I pause here for a minute. Their lordships are now comparing Delhi law's case and this provision in the constitution. Now my humble submission is that as far as Delhi laws is concerned, is ordinary statute. Therefore, there can be a more flexibility.
Yes.
But when you are dealing with a constitutional document, the limitations should be on a higher scale. This point is missed out. Kindly see further. The question that came for consideration in the Delhi law's case was with respect to the power delegation.
Yes, Mr. Nafta, I think we've got your point that you have to have some implied limitations, and therefore these observations in para 4 are of a very broad amplitude.
Your lordship sees the para 4.
We'll have to hear the other side. You made your point. We'll hear the other side on this.
Completely wipe out.
All right. What is the next point, Mr. Nafta?
So my next point is, which I will indicate at the end, because I have to deal with Article 3 and 4 as briefly as possible. But my next point is what happens to the Constitution of Jammu Kashmir. That's a thorny question. So if I recapitulate the facts which have been extensively set out in Premnath Kaul's case and which has been cited before your lordship.
So what is the submission on this aspect?
The submission which I want to make is this. So it traces out, the judgment traces out how the sovereignty came to be vested in the Yuvraj. Right from 1925 to 1951 or 49. And thereafter, two important developments. Yuvraj accepts the Constitution of India. But that is in the light of Clause 8 of the Treaty of Accession. Clause 8 recognizes that barring a few items, the sovereignty of the Maharaja remains. Now this sovereignty, which is recognized by the accession treaty, where and when does it evaporate? That's the question. Because as a result of this constitutional order and the Reorganization Act, the result is the Jammu and Kashmir Constitution comes to an end. Now let me elaborate this point, sir.
But that's postulated, and over the passage of time, period of time, what was left, as pointed out by Dr. Ravan, was only limited, very, very limited. Small.
Several provisions came to be applied, no difficulty. But the core of the J&K Constitution has remained intact till end, which I will indicate to your lordship. So therefore, your lordship will see that it is in 1951 that Yuvraj convened the Constituent Assembly. to frame the constitution. What is the authority by which he could do so? His authority to convene a constituent assembly has not been questioned anywhere. So therefore, J&K constitution is a constitutional document. That's the only conclusion possible. Now my submission is going to be that no matter how widely you interpret the power under 371D, the core of the J&K constitution must remain. And what is that core? Kindly come to J&K constitution. That is in volume 2. So in the first place, the state.
So can you itemize the core? I mean, can you just sort of summarize what would be the core?
The core I am indicating, that is part 5 and part 6 of the J&K constitution.
That is the executive.
That is part 5 is executive and part 6 is the legislature.
Additional document volume 2. Additional document.
Sir, when the constitution was ushered in,
Which is one more provision? Part 5 is the
executive, governor, council of
Part 6
ministers,
is the
etc.,
legislature, and what else?
and the legislature.
These two.
And kindly see,
You said one more.
section 3 and 4. Sections 3
Document compilation. Document volume.
and 5. That is part 2.
Yes.
Now the state of Jammu and Kashmir has its origin also in this, its continuation. It originally existed. There is a long history which has been set out in Ramnath Kaul's case, right up to independence, 1947 Act, Treaty of Accession, etc. Now kindly see the territory, section 4. Constitution.
पूरा वही document है.
The territory, the PDF page is 18. The territory of the state shall comprise all territories which on the 15th day of August 1947 were under the sovereignty and suzerainty of the ruler of the state. Now this is the territorial integrity of the state. Now there is no provision in the Constitution of India by which the J&K Constitution can be abrogated. There is no express provision. The only question is whether through the route of 371D this can be achieved. Now this depends upon the question, because Article 370 itself recognizes the Constituent Assembly. And the concept of Constituent Assembly is that it's a sovereign body. Now there can be a constitution within a constitution. That is something which your lordships have recognized. I just indicate to your lordship. That your lordship will find in the judgment of Yeshwananda Bharati. Para 2072. I just indicate PDF page 79091,
Volume,
volume 15, sir.
We'll look at it. Page, just give us the page 70,
790.
which says that there can be a constitution within a constitution.
Constitution.
All right.
That's what
Whose judgment is that?
Justice Chandrachud. Now, therefore, your lordship see the existence of level portion.
it should write that.
Yes.
Thus, the true ground of division by virtue of which the nature of the constitution is whether it is flexible or rigid. That depends upon whether the process of constitutional lawmaking is or is not identical with the process of ordinary lawmaking. A typical instance of flexible constitution is that of United Kingdom. The constitution of the former kingdom of Italy was also flexible, so flexible indeed that Mussolini was able to profoundly violate the spirit of the constitution without having to denounce it. The constitution of the United States is rigid as it cannot be amended without the special machinery being set in motion for this purpose. In short, we may say that the constitution which cannot be bent without being broken is a rigid constitution. The Indian constitution, considered as a whole, is a controlled or a rigid constitution because broadly none of the articles of the constitution can be amended otherwise than by special procedure prescribed by Article 368. Certain provisions, therefore, like Article 4, read with Articles 2 and 3, Article 169, Para 7 of the 5th Schedule, and Para 21 of the 6th Schedule confer power to amend the provisions of the Constitution by ordinary lawmaking process. But these amendments are expressly accepted by the respective provisions from the purview of Article 368. Schedules 5 and 6 of the Constitution are in fact constitution within a constitution. So therefore, the existence of J&K Constitution is recognized by the Constitution of India. How do I show that? Kindly turn to Article 370.
That you need not labor because according to you, the
It refers to.
Constituent Assembly itself.
Now the question therefore is that if the Jammu and Kashmir Constituent Assembly was convened by a sovereign authority, that sovereignty merges into the sovereignty of the Constituent Assembly and it ultimately gets transferred to the Constitution of Jammu and Kashmir. Now, therefore, you have two sets of documents. Article 371D, if it is deployed in such a manner that it results in the complete abrogation of J&K Constitution, is something which is, in my respectful submission, not contemplated.
All right. What is the next point, Mr. Nafide?
So my next point is, now, originally there were two routes. One was 373 itself. After 1957, that route is closed.
Yes.
Then we take recourse to Article 368. So in Para 7 of the judgment in Sampat Prakash, Para 7 in Sampat Prakash,
Yes.
it was relied upon by Mr. Dave. I don't wish to therefore repeat that.
Para 7 of Sampat Prakash.
Sampat Prakash.
What is the submission on that?
Justice Dave, Mr. Dave said that your lordships in this judgment have recognized that Article 373 is still in force. This is much after 1957. Now that route is obviously closed. But Sampat Prakash goes a step forward and says that even with reference to 368, you can't do it. Para 13. Para 13 of Sampat Prakash, I'll show to your lordship that your lordship will get PDF, volume 1, PDF 33. Now this, in my respectful submission, is no longer good law. In view of what the 11 judgments in Keshavananda Bharati say. Every judgment in Keshavananda Bharati says that every part of the constitution can be amended. Of course, some judgments take a view subject to the rider that basic structure can't be touched. But there is not a single judgment in Keshavananda Bharati which carves out an exception. And therefore, in my respectful submission, the only route which was constitutionally permissible is through 68.
That's what Mr. Dave has also argued.
Yes, that's what. So therefore, to that extent, para 13 of Sampat Prakash is not a good law. But para 7 remains. So therefore the question of what do we do with J&K Constitution? The core provisions, as I said, part 5 and part 6. The executive and the legislature of J&K are created by J&K Constitution. Now, by reference to Articles 3 and 4, by taking recourse to Article 3 and 4, these constitutional provisions contained in J&K cannot be done away with. So two submissions in this regard. The framers of the Constitution were aware of the fact that the Constituent Assembly for J&K is in the offing, clearly reflected in Article 370. Now, therefore, the question is that does it not contemplate, when it says that provisions, this Article 370 special status, provisions of the Indian Constitution can't be applied unless you follow a certain procedure, does it not contemplate clearly that the Constitution of India, as framed by the Constituent Assembly, recognizes the existence of J&K Constitution? And therefore, doing away with that can only be through a constitutional process. Now, therefore, your lordship will see that this is a limitation. The existence of J&K constitution is a limitation both on the power of the president under Article 371D, also the parliament's power under Articles 3 and 4. So part 6 of the Indian Constitution has never been applied to Jammu and Kashmir, except a few provisions here and there. But the core, the executive and the legislature, those provisions contained in the Indian Constitution have never been applied to J&K. In the judgment in NCT of Delhi versus Union of this is the 4 characteristics which your lordships have written. In paragraphs 292, 290, 291, 292, 296, 298 and 305. So kindly see what your lordships have said. The framers of the constitution were aware of the challenges which the new instituted democracy could face. In his address to the Constituent Assembly, but kindly come, my lord, to the straightaway to 305. This is the discussion which I don't wish to trouble you. PDF page 160. There are 4 abiding principles which are essential to the understanding the content of the Constitution. The first is that as a political document, the Constitution is an expression of the sovereignty of the people. This is satisfied by J&K Constitution because the Constituent Assembly was convened by the Maharaja, Yuvraj, because of clause 8 of the accession. The second is that the Constitution seeks to achieve its vision of a political and social ordering on the basis of democracy. A democratic form of government recognizes that the sovereignty resides within the people. Popular sovereignty can exist when democracy is meaningful. This is also satisfied. The third principle is that the Constitution adopts a republican form of government in which the powers of sovereignty are vested in the people and are exercised directly or through their elected representatives. This is also satisfied. The fourth, which is not the least in importance, in the secular ideology of the Constitution, for it is on the foundation of secular order that freedom, liberty, and dignity and equality to every citizen achieve. Now, if these are the 4 characteristics of a constitution, then in my respectful submission, J&K Constitution satisfies that. Now, when we talk of sovereignty, it does not necessarily contemplate external sovereignty. I accept that the concept of sovereignty vis-a-vis J&K is not external sovereignty. Because defense, foreign affairs, etc. are the subjects were already accepted in the accession treaty. I am not therefore suggesting for a moment that this sovereignty is absolute in the sense in which that concept is understood in international law. I wonder whether given the current scenario under the international law, is there anything called absolute sovereignty? Because there are so many conventions by which the state bind themselves. And your lordships have recognized that your lordship's courts can enforce the international conventions, though India may not have ratified them. So therefore, the absolute sovereignty concept, which was some 200 years ago, is no longer exists even in international. But the fact remains that that concept of sovereignty has some content. And that content with regard to Jammu and Kashmir is that their internal affairs be conducted at least in accordance with Part 5 and Part 6 of the J&K Constitution. 371D can make only marginal inroads. Anything beyond that, which results in the constitution of J&K evaporating, it can never have been contemplated. Now, in the alternative, even if we accept the concept of internal sovereignty, with respect to other states,